Okay, good afternoon. Welcome to the Conducting Effective and Efficient Internal Investigations program. My name is Jeff Johnston. I'm a partner in the White Collar and Government Investigations group here at B&E. I'm happy to introduce my co-presenter, Becky Baker. Becky's a partner in our labor and employment group, and she and I, sometimes together, sometimes on our own, conduct internal investigations for clients on a regular basis. This is a practice, at least in my mind, that's a bit of a niche that isn't widely understood. Um, there are a number of misconceptions, such as an investigation is only for the most serious, written, formal allegations. Investigations are disruptive and will take years and cost millions of dollars. And if I hand over my investigation to outside counsel, I'm going to lose track of the scope and cost is going to get out of control. And I don't want that. And I don't think any of those are true. Becky and I have done investigations that took years and that had dozens of lawyers and cost millions of dollars. But we've also done investigations where it's just one of us and a junior associate, and we finish in in a couple of 3 weeks. And then we've done everything in between. We've done investigations where all we did was act as an advisor to the in-house team, and the in-house team did all the investigatory work. And so there's a lot of ways that an investigation can be structured and to achieve the result and the goal that you're trying to achieve. So with that in mind, I thought we would go through the anatomy of sort of an internal investigation and dispel some of these misconceptions and put you all in a better position to know how to handle a situation should something arise in the future. All right, so let's jump in. We're gonna go over the life cycle of investigation. We'll start at the beginning. Do we even need to do an investigation? Talk about the team, who's going to do the work. We'll talk about the process and the toolkit available in an investigation. We're going to talk about what do we do when we get to the end and we have results. And then we'll talk about the fallout that can sometimes come from an investigation, and in particular, dealing with whistleblowers, which can be a tricky area. So, all right, starting at the beginning, how do we find ourselves in a situation where we might have to do an investigation? Well, a lot of the times it's an external action. You receive a subpoena from the SEC. I actually got a voluntary request from the SEC the other day, voluntary in quotes. Grand jury subpoena, you get a lawsuit where raises issues you want to look into. Oftentimes the board will hear something that concerns them and the board will decide something needs to be looked into. And then sometimes there's public commentary or something from a short seller that might encourage the board to open an investigation. Becky, you want to talk about sort of the internal ways that something might come to an investigation?
Yeah, sure. I mean, there's obviously a variety of different ways. I think most days, all public companies and a lot of private companies as well have some sort of ethics or whistleblower hotline, and employees are very aware of those hotlines and they freely use them. It allows them to log a complaint anonymously if they want to, which, we find happens a lot of times. And then eventually they, will disclose themselves. But so getting one of those automated whistleblower hotline complaints, you also obviously get complaints to HR team, to managers. And that's something we'll talk a little bit more about later, but it's important, obviously that your managers recognize when someone has issued a quote complaint. It's not necessarily a formal words. It's not, I want the company to look into this. So making sure your supervisors understand when they need to elevate it to HR. So that's something like an internal investigation can take place is going to be important. Your internal audit team, that sparks a lot of internal investigations. And then oftentimes departing employees. And that's a big one where, it can be tempting to say, oh, well, this problem is on their way out the door.
Yeah.
And so,
or they're disgruntled, right?
or they're disgruntled
Yeah.
and, but great, thanks for letting us know. And then you don't look into it. If someone raises a complaint, even if they're no longer going to be part of your organization, it's invaluable to review that issue and see, is there something going on where we actually do need to address it?
And just to reiterate a point Becky made, there's no formality around a quote capital C complaint, right? Yeah, there's the hotline and everyone knows, all right, if it comes into the whistleblower hotline, that's a capital C complaint, right? But if somebody sticks their head in the supervisor's office and says, hey, I've been concerned about this, that's a complaint too. And I've had very sophisticated general counsels, tell me when we've gotten down the road in an investigation and I learn that the whistleblower hotline was not the first time the issue was raised, it had been raised informally earlier. I've had general counsel say, oh, no, but that wasn't a complaint. No, it is. It is a complaint. Anything that comes to your attention of potential wrongdoing is a complaint.
That's right. And I mean, once the manager has knowledge of it, the company has knowledge of it, and there's a variety of different laws that say you can't ignore it once the company has knowledge of it.
Yeah. Another time, well, there are times, and they're few and far between, but there are times when the board of directors has an actual duty to conduct an investigation, and that obviously can be a very serious issue. So the duty of loyalty and the sub-duties of good faith and oversight say that when directors are presented with red flags suggesting non-compliance or misconduct, they have to do something. Now, the law doesn't say you must take the following 9 steps. It leaves it to the judgment of the board, but you must take some reasonable action, and that's the standard that we applied, is was the action reasonable in light of what you're hearing? So you need to understand the cause and the scope of the issue. You need to put remedial measures. If something is, if there is ongoing harm to the company, you need to deal with that first. And then, of course, the law allows the board to rely upon subcommittees. And so oftentimes you see the audit committee run an investigation or a special committee if there's a need for independent directors. Under Delaware law, the law says that if a disinterested board acts in good faith, that conduct is protected by the business judgment rule. And that's what you want. The boards want that protection of the business judgment rule. But on the flip side, Delaware law says where directors fail to act in the face of a known duty to act, thereby demonstrating a conscious disregard for their responsibilities, they breach their duty of loyalty. And that's what we want to avoid there, is that breach of fiduciary duty claim.
And I would just add too, beyond just directors, having a duty of loyalty, there's a variety of laws that place this duty on an employer to respond. For example, the Texas Labor Code, it was amended, I say recently, now it's starting to get a little bit in our rearview mirror, but it was 2021. It used to require prompt remedial action in the event someone reported a sexual harassment allegation. And now it's immediate and appropriate corrective action. So, obviously we don't, it hasn't really been clarified what means immediate, but you want to get that investigation kicked off right away.
And so what things are we investigating? What are the types of factual scenarios that might lead to an investigation? So in my practice, it's a lot of accounting and financial reporting issues, often for public companies, but not always. For the public companies, there can be SEC disclosure issues that go to the MD&A and the risk factors, earnings guidance, those sorts of things. Oftentimes you see insider trading allegations that the company wants to look into, issues with regard to internal controls. And by that, I really mean sort of evasion of internal controls. Nowadays, we're seeing a lot of cybersecurity issues, sort of incident response, ransomware, malware, those sorts of things. For our oil and gas clients, there was a time when we did a lot of investigations around reserve reporting and whether those numbers were being manipulated. The standard that we typically see in these things is often we're applying a fiduciary duty standard. So it's a lot of fiduciary duty issues. And then there's also, for our international clients, Foreign Corrupt Practices Act issues. But Becky, talk about the types of things that you see in your practice.
Yeah, when we start touching on employment issues, the obvious one is HR issues, harassment, discrimination, safety in the workplace, things like that. But it's also other things, conflict of interest, you hear it came to the manager's attention that, our paper vendor, Pete's Paper, I heard our procurement manager say he gets to hang out at Pete's Ranch, whenever he wants to. When your supervisory team catches wind of that, that's something worth investigating. Your code of conduct issues as well, sometimes with employee aspects, managers, supervisors, HR teams can be very focused on sort of the HR policies, but it can also extend to your overarching governance policies as well. And, all kinds of different ways in which employees aren't necessarily following company policy, like your expense account issue. That's a big one where we kick off investigations because it can seem small. Oh, it was a duplicated receipt, what's going on? And then, sometimes it opens up a window into a lot of things you didn't want to know, but you should know.
But you should know, that's right. So just to give a few examples of sort of real world investigations that Becky and I have done. I did one a couple years ago where the CEO and the CFO of a public electric vehicle company hired a lawyer, and that lawyer sent a letter to the board of directors demanding they resign and accusing them of insider trading, breach of fiduciary duty, and mismanagement. It was all around some registered direct offerings the company had been doing. That one was a particularly thorny situation where you've got the C-suite fighting with the chairman and the board of directors. And as you can imagine, it's hard to sort of come out on the other side of that without some carnage. That one in particular, because of that, we needed to have disinterested directors conducting it. So there were two directors who were not alleged to have done any wrongdoing. And so we created a committee of two and they ran the investigation. You want to talk about this next one?
Yeah, so we had a public company, they got, once again, those anonymous hotline tips and email, and it accused a high-level executive of inappropriate personal conduct. And this is an executive with significant financial authority. So sort of immediately the GC and the CEO started thinking, gosh, do we have an issue here where this person could be subject to blackmail? Do we need to revoke their financial authorities and things like that? At the same time, this is a completely anonymous tip and you don't just want to embarrass the executive. So, do we ignore it? Do we just assume that it's nothing? I mean, the answer is no, you never assume that it's nothing. Stranger things have happened. We've seen all kinds of things in our careers. And so, the response is, it's a measured response. You do what you can do to determine the legitimacy of the source, of the facts. You do need to talk to that executive. Obviously companies need to be aware that off-duty conduct has a reputational image, can harm the company. At the same time, I always have to make the plug for the various employment laws. Some states have off-duty conduct laws that if an individual is engaged in lawful conduct outside of work, you can't necessarily take an adverse employment action against them. So it's a balancing act for sure, but I think that, the key there is no, you can't just ignore that fact pattern.
And on that conflict of interest thing that you mentioned earlier with Pete's paper, we did an investigation where departing executives, so C-suite executive departing, rightly could be referred to as disgruntled, but disgruntled people can be correct as well. On his way out the door, accused the CEO of sending consulting work to his buddies and the CFO of falsifying earnings guidance, public company. Obviously, these are serious allegations. Conflicts of interest, the falsifying earnings guidance can be securities fraud. And what made this interesting, and we see this from time to time, is at the time he was making this, in the same letter he made these allegations, he demanded the company pay him twice what he was owed in severance. And so, the company said, hey, this is just a shakedown. And you can certainly see it that way, but he's given us credible allegations that we need to look into. And we were able to look into them and determine that they were invalid, that is absolutely not what was happening. I had one, and this is where these issues can be difficult for public companies because of the constant need for periodic reporting, right? Every 3 months, you got to file a Q, you got to get the K out on time, and missing those deadlines is not something anybody wants to do. This was one where public company's director of technical accounting met the general counsel at his parking spot on a Monday morning, gave him a 5-page letter of resignation, all of her problems with their internal accounting and their public reporting. And she said, I'm giving you my 2 weeks notice because our 10Q is due in 10 weeks. And what she didn't realize is that what she had just dropped in the lap was a hand grenade that was about to explode, because 5 pages of allegations, to investigate those in 2 weeks is a difficult task, particularly when you're going to have to be transparent with your auditors and they're going to need to get comfort on their end that the numbers are right. So that was an around the clock exercise there. And then I think just move on here to the next one. Okay, so let's talk about investigation planning. Who should conduct the investigation? And I touched upon this earlier. Is this something that we as a company can handle internally? And lots of companies can. Do we need to bring in outside counsel and absorb the expense of that? Or is there some hybrid team we can put together? And I've done it where Becky and I have just advised on the scope and on the structure and on what the report should look like. That's not a whole lot of our time. We've done it where we had in-house folks do some of the interviews. We've done it where instead of hiring forensic accountants, we relied upon the in-house internal audit team. Or you have to worry about whether there's a conflict there, but sometimes you can rely upon someone in the finance or accounting team, and that way you don't have to absorb the expense of a forensic accounting team. And then sometimes you just do need to hire outside counsel. So, you think about what are the capacities we have internally? How serious are these allegations? And if they are true, how harmful can that be for the company? How important is we have privilege around this? Because bringing in outside counsel is better to protect the privilege. You want to talk about the seniority of the people involved, because, an in-house team, no matter how good they are, cannot investigate allegations against a board member or against someone in the C-suite, absent something pretty unusual. Do we need independence here? And that 20 years ago, independence was sort of a big watchword. I haven't had a government agent harass me over independence in a long time, but if you think you're ultimately going to be dealing with the government, or you think you're dealing with a derivative lawsuit where you're going to go and ask the court to dismiss it, well, then you absolutely need independence there. And then a soft factor, which actually came up on something recently where one of my clients did their own investigation, and I just sort of advised on the outside. And at the end, someone had to be terminated, and that employee had to be somebody that the CEO really liked. And so the CEO was pretty upset at that in-house lawyer for causing this to happen. And, one of the things we can do as outside counsel is be the bad guy. Your CEO is not mad at you, they're mad at us. And not that that's something we're excited about doing. But Becky, talk about sort of once you get the team in place, how do you get going?
So, I mean, the first thing you want to figure out is who's going to be running the show. And you want to think about what are the allegations that came through the door. Is this something where we need our, internal compliance counsel to be running the show because it's got heavy sort of SEC reporting aspects or financial or accounting sides of things? Is this more focused on employment issues, harassment, discrimination, SOX whistleblowing, things like that? And a lot of times it's a mix of both. And a lot of times it's a mix of both because employment laws are constantly changing. And when you're doing these investigations, who are you talking to? You're usually talking to employees. And so there's a bunch of minefields out there waiting for you as you do these investigations because these employment laws are changing all the time. You have to know what you can and can't say to the employee during the interview. You have to know what you should say to them to, help preempt potential retaliation claims in the future. It's things that are not just the obvious whistleblowing topics, but protection under the National Labor Relations Act, which applies to, non-unionized workforces as well. And, there are restrictions on what you can and can't tell an employee during the investigation. So figuring that out, up front when you staff your investigation team, and also, do you need some external assistance as well? And then you also want to think clearly about who's your client. Is this the company? Or is this the board? Or if it's the board, is it actually a specific board committee? And then you need to remember, who your client is and maintaining that attorney-client privilege with that client, the direction from that client that they've asked you to go in. And then you also want to make sure you're thinking about who's out there on my investigation team. They could potentially become fact witnesses depending on where this goes and if this ends up in litigation. And so you want to make sure you've thought about, look, you don't want your CEO out there obviously conducting the investigation. That person could then become a fact witness and you don't want that person to have to be deposed unnecessarily. So thinking about all of that up front can really save you some pain in the long run. Okay, once we've got that sorted out, what do we do? Obviously you've got to start with an initial meeting. You have identified who is the first person, I want to speak to in order to understand these allegations. And sometimes that is the reporter. A lot of times, particularly from the employment side of things, that's going to be the reporter. It may not be so much so in the SEC side of things because you may need to go and first understand what are the company's reporting practices or what are their accounting practices and things like that. But in any case, you need to be flexible too. You need to think about, okay, this was the scope of my investigation when it started at that initial meeting, but as things have gone on and we've received more facts, now we need to shift and now we need to speak to this person. You also want to think about what laws might be implicated as you're walking through this, not just sort of what are the facts here and what's the purpose of the investigation. Are we trying to determine whether or not our reporting was accurate? Are we trying to determine whether or not we have a manager that we need to address conduct going forward in the workplace? Are we dealing with just a matter of sort of public image? And as you do that, you're outlining the scope of your investigation. You're thinking about who we need to talk to. You're ensuring you've preserved your evidence. You're thinking about how you're going to gather your data. And you're also considering, in some cases, do we need to get some employees out of the workplace while this is going on? Does someone need to go on paid or unpaid leave? Um, and then also you want to consider your outside resources. Very often we need, an IT resource to come in and preserve hard drives or, save data. So we also rely on forensic accountants and those forensic data experts that, very usually we don't have in-house. But also you want to think about making sure you've maintained your privilege whenever you do retain those third parties. You need an engagement letter. You need the sort of magic language that says that, the attorney this person is assisting the attorney so that that person can provide legal advice to the client.
Another thing you need to think about in the planning phase are there other stakeholders you're going to have to deal with? So on a public company basis, this comes up all the time. Private company, it's relevant as well. Do you have to get the auditors involved? And, it's always my advice that we should involve the auditors, particularly on anything related to the financials, SEC disclosures, the control environment, or the trustworthiness or the ethics of senior management, because the auditors take a rep from senior management. And if it's determined that they're not trustworthy, that's going to impact the auditor's work, and they're not going to want to take a rep from that person. So, and that's the kind of thing where you don't get an immediate reaction from the auditors. They're going to go back in-house, talk to their own experts, and think about it for a while. So you can't tell them the day your Q is due. You're not going to get your Q filed. You need to give them as much heads up as possible. And then oftentimes, the Big Four in particular, will assign somebody to shadow your investigation. They want to look at your document collection. They want to look at your search terms. They want to look at your date ranges you're using. They want to look at who you're interviewing, and they want to see the interview memos. You got to be very careful with privilege, because your auditor is not inside the attorney-client privilege. They can be inside the work product privilege, but they are not inside the attorney-client privilege. And this is the kind of thing where you don't want to have surprises when you're dealing with your auditor. Always got to consider the timing of, like, when's our next SEC filing due? And do we have enough time to get an answer before that? Are there any debt covenant issues that might be implicated by these allegations? And then think about at the beginning, who is our audience? Of course, the audience is always going to be, let's say you've been hired by the board or the audit committee or a special committee. That's your immediate audience. But if your immediate audience is the audit committee, you're probably going to also have to report to the full board, probably with management in attendance. And so just think about that. And then you're going to have to report at the end to the auditors. And as I said, they're not inside your attorney-client privilege. And so you need to think about, how can I create a non-privileged version, because facts are not privileged, a non-privileged version that I can satisfy the auditors with, but I don't waive my attorney-client privilege. All right, let's talk about, once you get into this thing, what are the information? Because look, an investigation is, you look at documents and you talk to people. I mean, that is at its base, that's what it is. So data preservation, litigation hold where appropriate, so that you can't say such and such has alleged the following, but you can find a way to send out a litigation hold that will preserve what you need. If the investigation goes on for too long, you'll want to send reminders out on that. And then you start the data collection. You see less and less and less of this now, but there's hard copy documents on people's desks that have notes in the marginalia, and sometimes that's important. Obviously, you need the electronic data, and as Becky touched upon, that's a question of who can do that collection for sophisticated entities. And maybe, I think it's been a while since I've needed to really bring in a third-party vendor to do a data collection. I think most internal IT functions now can do an export in a way that our internal team here at Vini can receive. And then we've got our own relativity license. And so we've got the tools that we need to do the searches and to review the documents. And so that's become more streamlined nowadays. Uh, and then you start thinking about, all right, what are the sources of the data? Obviously, the laptops and PCs, and to the extent they're external drives and shared drives and cloud drives, you need to understand where people are keeping data. I'm going to come back to this, but mobile devices are a huge part of this, and an increasingly huge part of this now are the IMs and the text messages. You got to get the IMs because that's where they're having the candid conversations. They're not having them in the email. They're not even really having text message anymore. It's in Teams. It's in the Zoom chat. And so, clients tend to be one of two ways. They delete things, those chats very quickly, and that is what it is, or they never delete them. And then you've got a record you can look at. Somebody's got to review those documents, right? And it's certainly not going to be me at my hourly rate. And so you want to search terms, date restrictions. We will get, if we're doing it here at V&E, we'll get, a team of junior lawyers to do that with the assistance of a paralegal and maybe a mid-level doing some QC on a big project. We bring in contract lawyers. Contract lawyers are significantly cheaper than we are. And they're very good at it because all they do day in and day out is doc review, and they get good at the tools and they get efficient at that. And so we end up doing that a lot. But I want to, on the mobile devices, and maybe this isn't limited to mobile devices, Becky, but talk about from the employment side, like what rights do you have to get your hands on that employee's data?
Right. I mean, it's really important to review not just your internal policies to see what has my employee signed off on. Have they said, yeah, you have full access to my mobile device or even my personal phone that I use for work? And what specifically are they aware of? Because there's a variety of different state laws. And again, they are constantly changing. And in some states, there are limitations on what type of searching you can do on an employee's system without having their, consent. And so reviewing your policies and then reviewing state laws to ensure that you're up to date with those policies before just diving in. And practically speaking too, something to think about is the timing of this and trying to catch that information and capture the data as it exists before an employee even knows an investigation is going on. If you schedule the meeting with them and then afterwards you do that, hard drive capture, it may not be quite so helpful. So obviously that's not going to be with every witness that you interview, but thinking about the timing of being able to preserve that data is important.
Okay, so I said that investigations at the base are looking at documents and interviewing witnesses. So talk about that second part, interviewing witnesses.
Sure. So, obviously having these employees speak to you and speak to you openly and honestly is what you're looking for in an investigation. However, you do have to remember if an attorney, in-house attorney, external counsel is participating in that interview of your employee, there's a famous Supreme Court case, Upjohn. I'm sure most folks have heard of that before, and you've got to give that Upjohn warning before you start your interview. And the importance of that is preserving the attorney-client privilege for the company. You are expressly telling that employee that you represent the company, you don't represent the individual, and that the communications are privileged, and it's the company that controls that privilege. So the employee doesn't have the ability to waive that privilege. And look, I've had conversations with in-house counsel before where they say, just this mean every time I walk in a room and, just casually am asking about someone, do I have to give this Upjohn warning? No, use your judgment for sure. But I would say in general, if you're sitting down to do a witness interview with an employee as part of an investigation, you definitely want to give that Upjohn warning. It's not something you expect them to blurt out every time they go in a room, but you don't want to forget that.
And can I just interrupt?
Yeah.
And you want to document that you did it. And
Yes.
so, and if you're in-house and you're doing witness interviews, you should never do them alone. You need somebody with you so that if there's ever a question about what somebody said, you've got backup. And preferably, somebody's taking notes. And the way that we do it someone is taking notes live, they clean that up and we have an interview memo in the file after the fact. But
Exactly.
sorry for interrupting.
Yeah, no, that's a very important thing to do. And so, okay, so, that's the overarching reminder to our attorneys. But when you think about what else do you need to consider when you're preparing your witness interview list, you want to think about, who do I speak to first? Is that going to be the person who brought the allegations? Is that going to be somebody else I need to understand some of the background, I think, before I spoke to the person who brought the allegations? And again, I think I generally lean towards talking with the, accuser initially if it's a harassment discrimination type complaint, but that may not be the case for everything. And then you also want to think about, am I going to get to talk to this person again? Sometimes you get an employee who speaks to an attorney, and after that initial encounter, they think, I don't really want to keep speaking to the attorney, or I'm not going to be so free next time I talk to the attorney. So you want to think about whether you're going to get sort of one bite at the apple or multiple interviews with this person. You might get the question from the employee, particularly once you share that Upjohn warning, do I need a lawyer? And I want my lawyer present. And I think the response to that is, we typically try to sort of give the employee a certain level of comfort. No, that you don't need a lawyer here. I think it's more of an issue if you're speaking to the person about whom accusations have been levied. At that point, it's possible that, they may need a lawyer at some point. But I think the answer you should be prepared to give is, I'm just trying to gather information right now on behalf of the company. In my role as the company's attorney, I am trying to understand, what information you have, and kind of leave it at that. If they ask if they can record the conversation, generally the answer we would suggest someone gives is, I'm not recording this. I really just want us to be able to talk. My purpose of meeting with you today is so that I can understand facts. And so, I'm not going to record the conversation, and I would ask that you don't record the conversation either. And if they say, well, I'm not talking without recording it, a lot of times that's let's table this and reconvene. Mentioned Upjohn before. Weingarten is another case that applies in the event you're interviewing a unionized employee. So if you're having a discussion about something that could ultimately lead to discipline for the unionized employee, they have a right to have a union representative present. And then you want to think about too, sort of moving on from the talking to the people. Okay, what do we start putting in writing? You want to think about what your memos are looking like, and are you maintaining that privilege, and who are you sharing those written memos with? You want to be very cautious to hit forward on things. And then lastly, I'd say, I hate to even have to bring this up, but in this day and age, you do sometimes have to think about security considerations. Is this a meeting we want to have maybe on a Friday afternoon when there's fewer people in the office? Is this a meeting that we think could end in someone getting very upset such that we maybe need to have security present? Is this a meeting we want to maybe do virtually? So, again, hopefully it's not an issue that comes up often, but it's just something to think about as you're figuring out who to speak to.
And this is a slightly different issue, but related, is sort of, and maybe it's security, but you're dealing with allegations and people's reputations are at stake. And if a rumor mill gets started, you could ruin somebody's reputation, even though at the end of the day, you conclude there's been no wrongdoing. And so, just encourage people you talk to not to start the rumor mill. I had an investigation where, because the client, look, when I come in with a team in suits and ties, people notice, right? And if their conference center is glass walls and everybody can see what I'm doing and who I'm talking to, that's not particularly discreet. And so you need to think about that as well. And there've been times, nowadays, frankly, we're doing Zoom interviews. And so that's about as discreet as you can get. But I've had ones where the client rented out a conference room at a nearby hotel and we did the investigation out of the hotel ballroom. So
Exactly.
something to think about.
All right.
Okay, a couple questions real quick. Question regarding your comments about instant messaging. What's your recommendation? To regularly delete or to retain all? So, Circumstances vary, but not knowing the specifics of any particular company, my recommendation, I'm interested in you agree with me, is to regularly delete. Have a policy, whether it be 7-day, 14-day, and just follow that policy. And make sure you understand. I had a client that had that policy, but their system had a thing where when someone didn't respond to a text message, to an IM for a certain period of time, that system would email that discussion chain to them via email. So they thought they were deleting everything, and no, it was just all in the emails. So you got to understand those sorts of things.
Yeah, no, I actually tend to agree. I mean, people treat IMs like a conversation. They don't think what they're putting in the IM is going to last forever. And so they're a lot more casual, and it can, oftentimes that's where the bad stuff is that you would really hate to have to, have made public. And so, I think it's especially the amount of volume produced by IMs, employees tend to use it. I mean, you're creating a transcript of people's conversations essentially, which is typically not what you want.
Yeah. And then second question, do we utilize any artificial intelligence in our data collection and review process? We don't at the moment. We are certainly testing that. We're really sort of being very, very careful with using AI in the legal practice, but it's something we're actively looking at, and I suspect we'll be using here in the future. All right, let's talk about protecting privileges and just put through this here pretty quickly. As I've mentioned, you sort of got both the attorney-client and the attorney-work product privilege at issue. To preserve that, you want to make sure that the investigation is being run by counsel for the purpose of providing legal advice. And oftentimes, the result of investigation is sort of mixed business and legal. And so, for example, if you find a misstatement in the financials that leads to a restatement, okay, that restatement is not protected by a privilege, right? The stuff people tell us is, but the actual changing of the numbers is just never going to be privileged. And so you just need to be thoughtful about areas where you're not really giving legal advice. I like to do sort of an investigation planning memo at the beginning that lays out what we're doing and has a legal purpose in there. Becky touched upon the Upjohn warnings. Those are important because the risk of not doing an Upjohn warning is at the end of an investigation when you are dealing with a government agency, for example, and you need to go in and present to them, that employee says, I thought you were my lawyer and I'm not authorizing you to tell anybody what I said. And then that becomes a problem.
Right. Yeah, and then the other aspect of employee concerns is confidentiality instructions to these employees, which is not exactly privilege, but comes in the same conversation. It's almost standard, I feel like, for when folks are doing an investigation that you tell that employee you would appreciate and you expect them to keep your meeting confidential. And I mean, that stems from the idea of integrity of the investigation. It seems to make sense. If you go and share with others what we talked about, they might align their story, they might have their memory clouded, even if it's not intentional. So there's generally legitimate reasons to want to tell that person you're speaking with, hey, let's keep this confidential so that, we can preserve the integrity of the investigation. Unfortunately, the pendulum has been swinging back and forth under the National Labor Relations Board. And for several years, we enjoyed a time where you could give that confidentiality instruction freely and really not worry about it. Or you could have a policy that said all, company investigations are confidential. You can't discuss them. Where we are right now is that you can't have a blanket confidentiality requirement. You shouldn't go into every single interview and read off the confidential information of the investigation requirements and tell the individual you can't tell anybody about this investigation. The current standard for whether or not this type of work policy violates an individual's rights under the National Labor Relations Act is that you have to analyze it from the perspective of the employee who is receiving that instruction. And if that employee would reasonably think that their rights to engage in protected activity under the NLRA, things like talk about their terms and conditions of employment, if they think that that right is restricted in any way that's in an unlawful manner, that can be a National Labor Relations Act violation. So you have to be very thoughtful about what you say and how you say in terms of, let's keep this between us. And it really should be saved for scenarios where there's legitimate reason to believe that that instruction is, has a legitimate business purpose. All
Okay,
right.
the next issue on privileges waiver, right? And we touched upon this earlier. The auditors are not within the privilege, the government's not within the privilege, and oftentimes you have to deal with them. And so you can't, just saying we're not waiving privilege doesn't really get you anywhere, because the auditors are gonna say, if you can't get us comfortable that there's no wrongdoing or no errors in the financials or no material weaknesses in the internal controls, we're not signing, right? And so you have to get them comfortable. The government, if you want them to go away or you want to cut a deal, you're gonna have to tell them what you did and what you found. And so you just have to be very thoughtful about, can you create a non-privileged version of that? And in particular, when you're dealing with reports, can you create two separate reports, one that you think is privileged and one that you think is non-privileged? And that way, if you ever have to sort of get in litigation and produce something, it's clear which one someone saw. Having said all that, you always have to go into this assuming the privilege is gonna get waived. Um, Oftentimes, it can be a strategic issue when you're dealing with government agencies to waive privilege where we have nothing to hide. And so in doing that, you need to have good hygiene as you're going through it. Your team needs to, they should do this anyway, but we don't need, oh my God, can you believe what I just found in the emails? We don't need, this is criminal in the emails. Just stick to the facts. Just good email hygiene. And then avoid having multiple drafts. We talked about interview memorandum. Um, Oftentimes, the person taking the notes is a junior associate who doesn't understand the intricacies of the securities laws, for example, and they may not get something exactly right. And when I look at it, I'm going to change it because I understand what that witness said and what it means under the securities laws, because that's what they said. If we have two versions of that memo, someone's going to think I'm putting my thumb on the scale here, which is not what was happening. And so, our practice is to have one version of the document. You edit that online, and at the end of the day, that version is the final, and there is no draft anywhere. And you also have to avoid emailing that document around. All right, let's get to the end. You've done your work, and now you're ready to report. So the first question is, and you should have thought about this at the beginning, who are we reporting to? The client, the committee, and then maybe the board, right? Talked about the auditors, talked about the government. Becky, I'm interested in your thoughts on this. You've got a whistleblower who's raised something. You've talked to them, and now you've got a conclusion. Do you tell them?
Yeah.
Or do you not tell them? You can't control them, and you don't know what they're going to do with that information.
Yeah, that's exactly right. I mean, you can't ice out a whistleblower. It's never going to work out well. Now, when I say don't ice them out, I also mean don't give them your report or share every detail of what the investigation found. But it is so important when you have an individual who has raised concerns, either about the way the company is operating in terms of its controls, its finances, or personally, the way I'm being treated as an employee. They are going out on a limb and telling you this information, and they think it's really important. And this is like a human element of these investigations. It is, you've got to go back to them at the end of it, and you've got to tell them something. And what you're going to tell them depends on, what you found and how you're proceeding. Again, if it's something where they were accusing another employee of doing something, you're not going to tell them how that employee was disciplined. You're not going to, tell them the specifics of what you found. But what you are going to do is you're going to thank them for bringing the complaint to your attention. You're going to let them know that the company took it very seriously. You're going to let them know, you might even let them know we interviewed a dozen folks. You might even know we've been looking at this for, 2 weeks. The degree of specifics that you give them are going to be, fact specific on your investigation, but you're going to say things to them to where they feel like, I was heard. This complaint was taken seriously. And sometimes you might tell them that, we weren't able to substantiate your allegations. And sometimes you might tell them we weren't able to fully substantiate your allegations, but in any case, we've responded. Sometimes you go down the list and you say how you responded. You say, we implemented this new policy, or this person's no longer going to work, is no longer going to be your supervisor, or, things like that. But essentially, it's a conversation with that person to where they feel heard and they feel as though the company did conduct a legitimate investigation. And it doesn't mean that you're going to tell them every detail of what the investigation found.
A whistleblower who does not feel like they've been heard or taken seriously is far more likely to take their complaints directly to the government, and then you're in a different situation. So, a couple other things about reporting. I think particularly when you're doing an independent investigation and either the government or a court might be reviewing it afterwards, progress reports are really important. You need to show that your client was actively involved in the matter and it wasn't just a lawyer-driven thing. What does the report look like? You can have a 100-page written report with footnotes and exhibits. Those are expensive. You can have a much shorter memo that sort of gets to the point. My default is a PowerPoint that I'm giving my results in a PowerPoint, and I'm going to say a lot of things that are not on the page. And then sometimes I just do a pure oral report where I've got my talking points, but nobody's ever going to see them but me. And then always, and we should have touched upon this earlier, when you think about staffing, what I think about in staffing, particularly for a public company, I'm always going to have one of my capital markets partners on the team so that I don't trip over an SEC disclosure issue, that I don't trip over something when somebody says, oh, now we got to 8K that. I want to have somebody who understands the securities disclosure rules better than I do, sort of looking over my shoulder. I always want to have an employment lawyer because there are going to be employment law decisions that have to be made. Okay, let's talk about managing a whistleblower and, importantly, avoiding retaliation claims.
So, when we say that, a whistleblower and retaliation, those words, a lot of times they sort of merge together. And so, I thought it's helpful to identify that a whistleblower is somebody who reports a violation of law or a violation of company policy. That makes them a quote whistleblower. But then that in and of itself is not necessarily something that has an impact. Retaliation is an adverse action taken against someone who is a whistleblower, or who, maybe they don't meet the statutory definition of a whistleblower in some circumstances, but someone who has engaged in protected activity. And whistleblowing, is generally protected activity. So what is protected conduct? It's going to depend on the arena that you're in. Are we talking about statutory conduct? In that case, it's often reporting something to the government. It can be internal reporting, depending on who it was reported to and the substance of the communication. But it can also be participating in an investigation. It can be protected activity where adverse employment actions can't be taken, even if it's within the scope of their job. Now, that's, again, not always the case, but that's one of those nuances you want to understand as you're going through the investigation. Lawyers and compliance officers can still be engaging in protected conduct, even when they are engaged in activities that you would typically think of as part of their job as the company's lawyer. And that typically comes up for your public companies under Dodd-Frank and SOX. And then employees, they may be excluded from certain bounty programs, those, government programs that say, hey, if you bring us information, you could get a payment from it. They might be excluded from the protections of that, but they could still be protected by various retaliation provisions, which are those provisions that fall on the employer that say you can't take the negative action against them because they engaged in that conduct. So as you're going into the investigation, that's something you want to kind of have at the forefront of your mind is, does this person have some sort of relationship with the company that puts them in this whistleblower category? So what is it when I say you can't engage in retaliation against a whistleblower? What does that mean? It really means you can't take an adverse employment action against them. But it can also mean, people think, oh, well, you can't fire the person. Well, there can also be other ways that the government looks at you retaliating against a whistleblower. And something that is very common in various types of agreements with employees, between companies and employees, are confidentiality provisions. You find them in employment agreements. You find them in restrictive covenant agreements. You find them in handbooks. You find them in separation agreements, which is very common in the context of an investigation. At the end of it, you might be separating someone. And it's language that says, essentially, you can't disclose the company's confidential information. And government agencies, the SEC in particular, but also the EEOC, the NLRB, they are laser focused on the language like this in employee policies, agreements, handbooks. Anything that they think the individual who signs that agreement is going to read it and think, I can't go tell the government that this company is breaking the law, that is viewed as a violation of the law. That is viewed as, retaliation. You can't silence these whistleblowers. And again, that applies to written documents, but it can also apply to things that are said during investigations. And casual comments to the whistleblower, can count as retaliation. In terms of other types of retaliation, again, I mentioned earlier, people think, oh, I got fired and that was retaliation, but it can be smaller things. It can be, I was moved to a different floor, and maybe the employer did that because they thought that was the right thing to do. I was separating you from the person you were complaining about. We thought this was helpful, but now you're separated from the majority of your team, or you're sort of separated from the people that have, decision-making authority. And so you're being a little bit iced out. That could amount to an adverse employment action. Anything that has sort of a material consequence, if I get a negative review and that impacts my bonus, or that impacts my ability to get a promotion, that can be, retaliatory activity. Essentially, the test is, if this result would have dissuaded that employee from making the complaint, either to the government or internally, if it would have dissuaded them from doing that, then that's, essentially retaliation. And there's no sort of set definition. It's definitely going to be fact specific depending on what has gone on. But it's important to remember that as you're doing your investigation, because once the investigation has concluded, inevitably you're going to get management team who want to do something with the employee. Maybe it's a performance review. That's very common. Performance reviews or performance improvement plans come up shortly after the investigation. And you really want to think carefully about how you do that. So what does that mean? Okay, now I know all this sort of these landmines I need to think about. What are best practices? You want to have clear anti-retaliation policies that encourage internal reporting. You want to be able to show the government, we were not trying to silence our employees. We made it very clear that they could bring these concerns to our attention, or they could go speak to government agencies, and that we don't tolerate retaliation. Training your managers and your supervisors. I think I said this right at the beginning, which is ironic because now I'm right back to it here at the end of our presentation. But making sure your managers and supervisors understand reporting procedures. And that means when they hear something, they act on it. Either maybe they do it themselves, or they bring it to HR, they bring it to legal. If you've got someone who's lodged a complaint or engaged in protected conduct and then sort of nothing happens, it's going to be essentially easier to demonstrate retaliation if something bad happens to them. And clear anti-retaliation policies, practical approaches to your employee complaints. Again, practical approaches means being responsive. Don't just let it sit for 3 weeks. That, can make somebody who's lodged a complaint think you just don't care, and that gets them angry. And then they think, well, if you're not going to care, maybe a lawyer would care, or maybe the government agency would care. And then, managing employees and holding poor performers accountable. That can be the key to either, when we say holding poor performers accountable, a lot of times, not always, but folks who are raising complaints also happen to be the ones with performance issues. And so often you've got someone who, isn't getting along with their manager personally. And so they lodge some sort of, well, my manager's not following the financial controls or whatnot. and you address that, you're able to clear that, check the box, your investigation goes great, nope, all is good. Then we want to take action against the employee who complained, but we don't have a good track record of it. This is the first time they're getting disciplined. Well, what does that look like? That's going to look like you're disciplining me because I complained about my supervisor. And that's not what you want. So you want to have that, management of performance so that then if the whistleblower complaint comes up, you close it out, then you need to take some action. It doesn't necessarily look like it was solely tied to the investigation.
Let's talk for a second about frontline management and the folks who are most likely to receive, particularly an oral complaint. The managers need to understand their job is just to receive it. It's not to engage, it's not to investigate, it's not to admit anything. They receive it, make the person feel heard, and then pass the information up the chain so that the people, we want to get a privilege around this as quickly as we can. And so we need to get that to the folks who can actually handle the allegation. We're going to talk about that for a second.
Yeah. So what does that mean? Most of the time you want your managers to contact HR or the compliance team or legal, and you really want them to do that right away. Even if it turns out to be nothing, fine. You want to make sure that the complaint's not getting disclosed out, widely discussed. The fewer people that know about it, typically the better. Again, that way it protects the person who's made the allegations. You want to make sure your supervisors know they shouldn't be sort of deviating from typical policy without checking with HR or legal. You want to get that litigation hold notice out. That's incredibly important, making sure your documents are preserved. And you want to make sure that the individual understands that, you're conducting the investigation, the company's following its practices, and they're not sort of running the show. We've got a few real world examples. One example of retaliation is a company that issued a litigation hold notice to its team that said, Mary went to the SEC and complained, so now we all have to hold all of our documents.
Hopefully you all wouldn't do that.
Yeah. So just naming that person, because then she said she began to get treated differently by her colleagues. And, so that was retaliation. I think I mentioned this before, changes to your work structure that might isolate employees from colleagues. A lot of times maybe in this world of remote work, you don't typically remote work, but let's have you remote work for a while. That may, be considered retaliation depending on the circumstances. And then punishment in any type of form. And that doesn't just mean termination or a negative performance review. It's, not allowing someone to attend a function, changing their office location, moving their parking space. I've actually had that one before. So just anytime you're making a change to an employee's circumstances after they've raised concerns or after they've participated in an investigation, you need to kind of run it past your HR legal teams. I think we've actually touched on this. How do you manage that whistleblower? You want these folks who have brought allegations to your attention to feel like you appreciate that you did that they did that, they went out on a limb and did it, and that you took them seriously. I think something we didn't say before is sometimes the employee might be part of the solution. If that's the case, that's actually fantastic, because then they really feel empowered and they feel like you understood what they're saying and that they have something to help fix it. The goal is to try to figure out what it is that employee is looking for and see if you can fix it. And you can't always, but sometimes you can. But sort of managing their expectations is really important. And you do that throughout the process. You do that when you receive the complaint, throughout the interviews, and once the investigation has concluded. You want them to, again, feel like you appreciate that they brought this to your attention.
Well, that is conducting effective and efficient internal investigations. Thanks for your attention today. Becky and I are available if anybody has any questions after the fact. Thanks very much.
Thank you.